attorney.
City of Detroit versus Contrail Grigsby, case number SP168333921, SP1683393, counts 1 and counts 2. Appearance for the record, please.
And special appearance of Contrail Grigsby Jr., Shuri Juris and Proprio Persona.
That went over my head.
No rights. I do not waive none of my rights.
All right, Woody is today is the date and time set for a pretrial. What do you want to do with these cases?
Should be taking it. First, I want to I have added 2 pieces of documents to the court. I want to put them on a record. And my affidavit of conditional acceptance and my Naturalization Act of 1779 I already had on the record. So
I want to take it. You don't see this phone? All right. What do you? Okay, that's on record. What do you want to do with these cases?
I'm fighting.
All right. So you want a trial date?
Yes, sir.
I'm going to give you a jury trial date. Let a jury of his peers determine whether his innocence or guilt. Jury trial date, in person. The trial date will be in person.
Jury trial. Can handle this. Can this right be handled in private? I request that my this be.
In your honor, at this point, I would ask the court to allow me to withdraw. Mr. James did file a bar complaint against me. I feel at this point I have a conflict.
Mr. James, go ahead and activate your audio.
Yeah, I have no problem with that.
Well, I have a problem understanding what's going on. So you had previous counsel with SMH. You were then given conflict counsel with Mr. Smith. Are you planning to hire private counsel?
No, ma'am. I didn't ask him to withdraw.
Yourself?
No, ma'am. I didn't ask him to withdraw. He took it upon himself to do that. I have nothing to do with me.
Did you file a bar complaint against him?
Yes, I did.
Okay. And how do you think that's going to affect your working relationship with your attorney?
He needs to do his job. It was some things that you informed him to do that he did not do. For us getting the evidence for me to prove that I didn't commit this crime that you guys got me charged with. He was supposed to get in touch with Intoxalot. You told me that he don't have to get in touch with Intoxalot. I'm of the belief that's his duty to get in touch with Intoxalot to find out what's going on, and he haven't done his job. He made that decision. It wasn't me this time. He made this decision. I can't afford an attorney. I need another attorney.
Well, we don't have unlimited attorneys to give you. It sounds like you have issues with the attorneys that get assigned to you, and that.
All right, today's video is a double feature of courtroom chaos, and we're starting strong with a sovereign citizen speedrun. We're in Michigan, in Judge Perkins' courtroom, and this appearance is short, but packed with every SOVCIT buzzword you'd expect: special appearance, mispronounced Latin, imaginary legal personas, and a complete misunderstanding of how identity works in court. These cases are fascinating because they show how fast things unravel when someone tries to outlaw the law. And just when you think it can't get more detached from reality, we pivot into a second case where a defendant actively sabotages his own defense by filing a bar complaint against his lawyer, then demands a new one. 2 cases, 2 different flavors of self-inflicted damage, so stick around, because both of these end exactly how you'd expect.
My turn is, what was you referring to when I told you that I needed them to get in touch with Intoxalot? These are the people that are holding me in here, bringing false charges against me. Everything they charged me with, I served my punishment on that already. With Intoxalot charges.
Those are 2 different things, Mr. James, you are charged with driving on a suspended license. The issue is whether or not the Department of Licensing suspended your license, whether you were given notice and due process, and the information pertaining to your status, and whether you chose to drive after the fact. Those are the relevant issues. So you may have other concerns. I don't know your situation with Intoxalot. I know you have a beef with them about whether or not they conveyed information to someone. I believe that's what you've said previously.
Well, you guys are their enforcers. Y'all enforcing Intoxalot. I just spoke to DOL. They say they're not going to get involved with what's going on with me in Intoxalot.
That's right.
You can't make Intoxalot give them the compliance.
That is not, that's whether or not you had a valid license on the date of violation is the question.
Well,
So
This exchange right here is sovereign citizen logic in its purest form. The defendant is trying to create legal distance between himself and himself. By claiming a special appearance on behalf of some alternate version of his name, he's hoping to avoid the court's jurisdiction entirely. The problem? Courts recognize people, not word games. Judge Perkins cut straight through it. If you're not a licensed attorney, you cannot appear on behalf of another person, real or imaginary. And the judge even gives him what he wants procedurally, self-representation. But notice how quickly the threat of a warrant shuts down the performance. Reality has a way of interrupting fantasy.
charges, and that's why they're proceeding.
Correct.
They told the DOL informed me that they didn't suspend my license. They can't make Intoxalot give them the compliance. And Intoxalot sent me a settlement letter saying if I paid $139, I will receive my license back. I paid $139. They still haven't given me my license back. So they led me to believe if I pay this amount, they would give me my license back. The amount was paid, and they still have not gave me my license back. Now they're saying it's something else.
No, they've been playing this game with me showing for years. Suspended, Mr. James, as of right now, and there's a reinstatement condition that you have ignition interlock with compliance for at least 4 months. That is a requirement. The court said I complied. The sentencing court said I complied with the 4 months. What citizen court? I don't know what you're talking about. The court that sentenced me in Seattle District Court. Seattle District Court said I complied with my 4 months. They said they was monitoring me at the same time Intoxalot was monitoring me. They both had my car under GPS monitoring me. And the court that sentenced me to the 4 months, they said I complied with my 4 months. They said that they had a tab on me just like Intoxalot did. They said I'm finished. I talked to the clerk of court. They said they also was GPSing and monitoring my car during the same 4 months Intoxalot was. And they said I completed the 4 months. So if the court was monitoring me at the same time the Intoxalot was monitoring me for 4 months, the court said I completed it. Because if the court otherwise, what are you talking
otherwise
about?
they would have turned over.
Mr.
Otherwise,
James.
they would have notified
Mr. James,
DOL to suspend
Mr.
my license.
James, what court are you talking about? I think you hear what you want
King
to
County District Court. King County District Court, the court that sentenced me on the DUI charge. There is no other court, ma'am. The court that sentenced me on the DUI charge. The court that sentenced me to the 4 months compliance with the DUI. No more than 4 months. It could have been less than 4 months. It was on my car. The court that sentenced me was monitoring my car.
Right? The 2015
yes, ma'am.
case, you were sentenced in 2018.
This is where the pseudo-legal script really kicks in. Jurist, in propria persona, conditional acceptance, and a random reference to the Naturalization Act of 1779, none of which apply here in the way he thinks they do. Sovereign citizens love affidavits because they believe saying something on paper makes it binding on the court. It doesn't. Judges care about relevance, jurisdiction, and procedure. Judge Perkins listens, acknowledges the filings are on the record, and then immediately brings things back to reality with one simple question: what do you want to do with the case? Because no amount of historical cosplay changes that fundamental decision.
Court say they monitored me the whole 4 months I had the thing in my car. That was the court that sentenced me. That's Seattle District Court, the West Division. I talked to the clerk of court. They said they monitored the whole 4 months it was in my car. They said, and they sent me an order saying I successfully completed the 4 months. And that this case is closed. So if the court is saying I'm finished,
Mr.
and the
James,
Toxalot is saying I'm not finished, we have to go on what the sentencing court is saying. I'm going on what the sentencing court is saying.
well, then you are doing that to your detriment. So if you choose not to listen to your attorneys, you are still showing suspended. Your status is
My attorney haven't told me anything. My attorney is not even talking to me. He won't even get in touch with me. He haven't told me anything. One attorney said, Sean Parent said, I need to put it back in my car 11 more months. It was already in my car 14 months. And you keep saying I have to put it in there for 4 months. The machine was in my car for 14 total months until they was ordered to take it out of there. Had I would have taken it out, a warrant would have been placed for my arrest. I didn't take it out. The
There
people
are
who put it in my
Mr.
car
James,
took it out.
there could be two different things going on. The court may have ordered you to have an ignition interlock device as a condition of your release while the case was pending. If you entered a guilty plea to the DUI or were found guilty, then the Department of Licensing will impose certain restrictions based upon your plea. And that may be what's going on.
I did everything. I took the classes. I took the DUI classes. I paid all of
and I think your
victim fund.
DUI,
I did everything, all that. I did all that already.
Okay. If you would stop talking, I think your DUI case is closed, but you still have obligations to the Department of Licensing. They have their own systems in place. And
they told me I don't. They told me I don't. In a recent email that I got from them 2 weeks ago, they said they have nothing to do with this. They don't want it. They say this, everything that's going on, DOL told me, is between me and Intoxalot. They say I broke the conditions of Intoxalot, not DOL. They say that Intoxalot saying I broke the condition.
So, Mr. James, it appears to me that Intoxalot is not going to show that you're in compliance for whatever reason.
And here comes the final sovereign citizen Hail Mary, requesting a private hearing. This is a common move, and it always fails. Court proceedings are public by design. Transparency protects defendants, victims, and the integrity of the system. Judge Perkins shuts this down cleanly and professionally, and that's basically the end of this case from our perspective. Once it's set for jury trial, there's nothing left for the SOVCIT theatrics to accomplish. So with that performance wrapped up, we move into our second act, where the legal chaos is less imaginary, but just as self-destructive.
And that is your beef with Intoxalot. Okay? But if Intoxalot is not sending the proof to the court or to DOL, it's not the court, it's to DOL, then they're not going to lift the restriction. They're not going to show that.
I understand that, but it's DOL is not holding my DOL is have to go by what Intoxalot said.
Right. And
Everything
DOL,
you saying,
DOL does
I
not
know this.
have proof. DOL apparently does not have proof that you have the 4 months compliance.
Well, I told them they can contact the sentencing court. The sentencing court has the proof.
That is
otherwise
not,
they would have never told me.
Not the same. So, Mr. James, if you choose to just disregard what people are saying to you, you're just.
I'm going by what the law is saying. It's obviously you're not following the law, Your Honor. You're not following the law. You're upholding something illegal for Intoxalot. You're helping them mess over colored people. That's what you're doing. This is a racist act by you and Ms. McDonald and your entire courtroom. Y'all doing this against. Y'all don't do this to the Caucasians. I have sat in your courtroom. I have watched you not give Caucasians the Intoxalot machine. You did not put that in a car. Instead, you'll give them a fine. But every colored person come in your courtroom, you want to put this in a car and hold this against them the rest of their life. If Intoxalot had authority over me, then that means I'll have that thing in my car the rest of my life. If you give them the authority and you uphold Intoxalot authority, it's obviously you own Intoxalot in payroll. So it's obviously Intoxalot is paying you to mess with colored people. And that's what's going on. They paying you to mess with colored people and to keep that on their car.
Because you're saying a lot of things that don't make any sense at all. I'm not doing this to persons of color. That is simply not true. I'm
They
not.
doing this to everybody
looking for
over the United
Intoxalot.
States of
I don't have
color.
anything to do with Intoxalot. I don't think DOL cares.
You
who
upholding a
interlock
legal.
with.
First of all, no law should be enforced that deny me privileges and punish me. You can't use a law against me to keep denying me of privileges, and you intentionally doing it, Your Honor. You're intentionally using some old piece of law that somebody said to deny me privileges and to constantly punish me. I've been found guilty. I done served my time.
This is never a good sign. When a defense attorney asks to withdraw on the record due to a bar complaint filed by their own client, the relationship is effectively over. Attorneys are ethically required to avoid conflicts, and nothing poisons trust faster than accusing your lawyer of misconduct. The judge immediately zooms in on the real issue: how are we supposed to move forward if every attorney you're given becomes the enemy? Courts can appoint counsel, but they can't force mutual trust.